Welcome all, my dear friends. A very good morning to all of you. Let us continue our journey in the world of patents. Here, till now, we have discussed up to form number 17 and all its relevant rules and sections. So, today is the turn for form number 18. Okay, so when we go for form number 18, its relevant sections and rules, we have picked up. That means I got the common word between them, that the key term is request for examination. Okay, so let us try to compare this legal world or the key term of the legal world with a literary bent of mind, just to just a feel good factor, friends, nothing else. So here, look at this beautiful rose that has blossomed in the garden, and let us see, just observe what happens. Yeah, though the flower is so beautiful, still it is glowing. Okay, because there is a competition, we can say, and this particular rose has sent a request for examination. That means which flower will be awarded the number one. Okay, so that's why, though by default it is beautiful, it is also trying to show its beauty in a more effectful manner. That's why it is great. Just a literal comparison, nothing else. So let us proceed to our legal world, where we will deal with form number 18 and its relevant rules and sections. Fine. Okay, let us proceed, friends. Form number 18. The title is Request for Examination of Application for Patent. Okay. The related section is section 11B, and the related rules are Rule 20 and 24B. Exactly. Rule 20, Subrule 4, Clause 2, and Rule 24B, Subrule 1, Clause 1. Okay. So, now we will go into a little deeper. Okay, so what is the title for section 11B? The title is Request for Examination. Okay, and the title for rule number 20 is International Applications Designating or Designating and Electing India. Okay, rule number 24B is Examination of Application. Okay, so here we can very well see that the keyword here is examination. You can see here examination, here examination, examination. Okay, so we can say that the keyword here is the examination. Fine. So this way we can just remember Form 18, Section 11B, Rule 20 and 24B. Okay, so by simply uh, keeping all this related sections, rules and the form in mind, we can very well answer all the questions that can be asked in any exam. Fine. Okay. Today's section is section 11B, whose title is Request for Examination, and this comes from chapter 4, whose title is Publication and Examination of Applications. So let us proceed for the detailed explanation. Fine. Now, section 11B has 4 subsections in total. Okay, so I have picked some of the keywords or the key terms or the key phrases. As for my intellect and my convenience, you can choose your own, so that whenever if I can remember these keywords or the key phrases, then very well I can recall the respective subsections and the section as a whole. Okay, so let us proceed. For subsection 1, the key term or the key phrase is make a request. Okay, that means in subsection 1 a request has been made. Fine. And subsection 2, actually this is omitted, so it is not existing now. And for subsection 3, the key phrase is a claim for a patent filed under subsection 2 of section 5. Okay, so whenever we see this key term, we can very well remember that it talks something about the section number 5. Fine. Okay. Next, the key term for subsection 4 is withdrawn. So something is withdrawn, we can just recall, then we can go for the uh, whole subsection. Okay, so this way friends, just try to remember these key terms or the keywords and try to recall the respective subsections and the section as a whole. Okay, fine, let us proceed. Subsection 1 says, no application for a patent shall be examined unless the applicant or any other interested person makes a request in the prescribed manner for such examination within the prescribed period. Okay, so we can say friends, here the key term is make a request. That means some request has been made. And here I have written here below that refer rule 24b sub rule 1 clause 1 and section 152 subsection 2 clause id and form number 18. Okay, where rule 24b is examination of application, section 159 is power of central government to make rules, and form 18 is request for examination of application for patent. Okay, okay, so friends, just and friends, this whole subsection is actually substituted by Act 15 of 2005, Section 11A for subsection 1 with effective from 1st January 2005. Okay, so that's why the single star mark indicates that this the whole subsection has been substituted. Okay, so now let us analyze what it is. Okay, so in a very simple statement, I can say that subsection 1 says a patent application shall not be examined unless the applicant or any interested person or any other interested person, we can say, request in the prescribed manner for such examination within 48 months from the date of filing or the date of priority, whichever is earlier. Okay, and the request is done in form 18, where the title for form 18 is we know request or express request for examination of application for patent. Fine. And we can say that the statement is started in a negative approach, but I have started, that means the explanation I have started in a positive approach, but stating the same meaning. Fine. So I hope it is clear now. Let us proceed. Subsection 2 is actually omitted by the Patents Amendment Act 2005, or we can say it is omitted by Act 15 of 2005, Section 11B, that means Section 11, Subsection B, with effective from 1st January 2005. Fine. Next is subsection 3, and the whole subsection, that means subsection 3 is substituted by Act 15 of 2005, Section 11C for subsection 3 with effective from 1st January 2005. Okay, so let us see what it says. Subsection 3 says, in case of an application in respect of a claim for a patent filed under subsection 2 of section 5 before the first day of January 2005, a request for its examination shall be made in the prescribed manner and within the prescribed period by the applicant or any other interested person. Actually, friends, as section 5 is mentioned here, I would like to tell you one thing, that section 5 is not existing now. Okay, but it was about inventions where only methods or processes of manufacture patentable. Okay, this was the title of section 5, and this is replaced this is repealed by the Patents Amendment Act 2005. that is Act 15 of 2005. Fine. So the meaning is very clear. In case of an application in respect of a claim for a patent filed under subsection 2 of section 5, okay, before the 1st January 2005, okay, because after that it is repealed. A request for its examination shall be made in the prescribed manner and within the prescribed period by the applicant or any other interested person in the same way. Fine. Okay, so for this, please refer rule number 24B, sub rule 1, clause 2, where rule 24B is examination of application. And the whole subsection here, as I said it earlier, has been substituted by Act 15 of 2005, section 11, subsection C for subsection 3 with effective from 1st Jan 2005. I hope it is pretty much clear now. So let us proceed. Subsection 4. This says, in case the applicant or any other interested person does not make a request for examination of the application for a patent within the period as specified under subsection 1 or subsection 3, the application shall be treated as withdrawn by the applicant, provided that clause 1, the applicant may at any time after filing the application but before the grant of a patent withdraw the application by making a request in the prescribed manner, and clause 2, in a case where secrecy direction has been issued under section 35, the request for examination may be made within the prescribed period from the date of revocation of the secrecy direction. Okay, so friends, here you can see the single star mark. And within the square bracket you can see this indicates actually the words or subsection 2 omitted by Act 15 of 2005, section 11 subsection D clause 1 with effective from 1st January 2005. Okay, and the all the words inside the square brackets where double star marks are there, this has been substituted by Act 15 of 2005, section 11 subsection D clause 2 for proviso with effective from 1st January 2005. Okay, so now let us analyze the subsection. Okay, here the keyword is withdrawn. That means something is withdrawn. So let us analyze. In case the applicant or any other interested person does not make a request, if there is a situation that no one requests for an examination of the application within the prescribed period, then the application will be treated as withdrawn by the applicant. Fine. Provided that means there are some criteria as well. The applicant may at any time after filing the application but before grant of a patent withdraw the application by making a request in the prescribed manner. How he can withdraw? At any time after filing the application but before the grant of the patent. Okay, he can make a request for withdrawing the application in the prescribed manner. And the second criteria is, in a case where secrecy direction has been issued under section 35, the request for examination may be made within the prescribed period from the date of revocation of the secrecy direction. Okay, this is a special situation we can say. So another thing I would like to tell you, friends, request for withdrawal of a patent application is actually made via form number 29. Okay, so we can say that form number 29, uh, its relevant section is section 11B and the rules are rule 7 and rule number 26. Okay, so one thing I would like to mention here, the request for examination under section 11B, subsection 4, shall be made within 48 months from the date of filing or from the date of priority of the application or within 6 months from the date of revocation of the secrecy directions, whichever is later. Okay, so just remember these things, and I hope now it is pretty much clear. Friends, please go through all the subsections. Please go through the barrett, and if you have any doubts, please put them down in my comment box. Okay, so let us proceed. Finally, I just want to say that let us again go to this old picture, and here we have established the relationship between form number 18, section 11b, and rules 20 and 24b. Fine. And already we have discussed in this particular video lecture about section 11b. And friends, I just want you to recall that also I have prepared some separate video lectures for rule number 20 and rule number 24b as well. So in a way we can say that form number 18 along with all its relevant section and rules are completed actually. Okay, so in the next video lecture we will go, or we can jump up to the next form number. Fine. So if you have any queries regarding rule number 20 or 24b, please go to those separate videos and you can ask if you have any queries in the comment box of those rules. Fine. Okay. The reference is Patents Act 1970 as amended by Amendment Act 2005 and the Patents Rules 2003 as amended by Amendment Rules 2021. Thank you all, my dear friends, for your patience, for listening to me and watching my video. So please like, share and subscribe my channel. Stay safe, stay blessed. God bless you. Jai Hind.